Good morning, everyone, and thank you for joining us today. My name is Maya Lajami, and I'm a trial lawyer and CEO of ME Law. For those who don't know me or are attending our webinar for the first time, welcome. I am a litigator with a practice that spans everything from complex commercial disputes to personal real estate conflicts. Basically, if the deal goes sideways, I get the call. Think of me as the person you hope you never need until you really do. Today we're diving into one of the most stressful and increasingly common legal challenges in Ontario's real estate: failed closings. Whether you're a buyer, seller, broker, investor, or developer, a failed closing can derail a deal, damage reputations, and lead to costly, time-consuming litigation. Over the past few years, we've seen a dramatic shift in Ontario's real estate market. What was once a fleeting frenzy over asking offers and waived conditions. I do apologize. Give me one sec here. I think we have some issues here with our sound. Okay, so I do apologize. We're going to keep streaming, and we're going to figure out something here, and then we're going to continue. If we have to run over time, that's fine. Just give me one sec. We're figuring out something here. I do apologize. Thank you, everyone. Sorry about that. I do apologize. We did have technical difficulties, but we're hoping that everything is now worked out. I do have someone next to me in case I do have more issues. However, I just wanted to make sure that all the slides are up, and it will be available on YouTube, and we'll be able to give you a link to watch the stream after. Okay, so what we've seen, so back to what I was discussing. So over the past few years, we have seen a dramatic shift in Ontario's real estate market. What once was a fleeting frenzy of over asking offers, waived conditions, has now given way to basically economic pressure, financing instability, and builder side delays. Mortgage interest rates have surged, appraisals are falling short, and even in resale transactions, we're seeing a rise in buyers backing out at the 11th hour. In the pre-construction, it's not really unusual to see developers miss deadlines or buyers try to sign their units or their new built homes without success, all of which can trigger really serious legal fallouts. According to recent data, in the Greater Toronto area alone, we've seen a spike in failed new build transactions. Some estimates suggest as many as 1 in 5 pre-construction delays are at risk of falling through before completion. Now today what we're going to do is we're going to break it all down, not just from a real estate perspective, but from a legal one. We're going to discuss how these deals are structured, what actually causes them to fall apart, who's liable when they do, and most importantly, how you could protect yourself from ending up in court or losing a 6-figure deposit. This isn't just theory. We're actually going to walk through some real case examples, discuss court decisions in Ontario. What I mean by that is what potentially the court will decide, right, and outline practical strategies that you and your clients can apply immediately. At the end, we'll also open up the floor for a short Q&A session. So if something comes up during the webinar, make note of it and we'll try to cover it live. So grab a coffee and your breakfast bagel and let's dive in. Okay. Before we talk about disputes, we need to understand the foundation, how deals are structured. Every failed closing starts with a signed agreement, but what's inside the agreement and how it's managed often determines how vulnerable the deal is. So let's break it down. First, we'll cover resale deals, then we'll look at new builds. Okay. In resale transactions, let's say a buyer agrees to purchase a house in Toronto, The process begins with an agreement of purchase and sale, or what we call an APS. Okay, this is a typically standard ARIA form, but don't let the template fool you. The details inside can make or break a deal. Here's what it usually includes: a deposit, which is typically 5% due within 24 hours, held in trust by a listing brokerage. The deposit can change in terms of terms and agreements between the parties through the negotiation process. You have conditions which allow the buyer to walk away legally if unmet. These conditions are some things like financing approval, home inspection, review of status certificate if it's a condo that's being purchased. Every condition is time limited. Often it's 5 to 10 days. If the buyer doesn't waive the condition in writing, the deal automatically falls through. So in this very beginning of this negotiation and deal structure, you're working with a real estate agent. If not, and a lawyer's drafting it, the agreement, you're working closely with the lawyer. Once those conditions are waived, we enter what I like to call the danger zone. Okay, these deals are now firm. Both parties are contractually bound to close on the agreed date. From this point forward, any withdrawal can lead to a forfeited deposit, legal claims, and hefty litigation. You can also include a holdback in these deals. Okay, a holdback helps ensure that conditions like chattels being in working order. For example, let's say you're a buyer, you attend our house or condo, a resale house or condo that was listed for sale, and when you attended, the dryer, washer, microwave, dishwasher, etc., were all working order. They were all working. And now that they are not, you might want to include a holdback of, let's say, $5,000, which is held back. If the chattels are in working condition, then the money held back is given to the seller. Now, another way that the seller can protect themselves in terms of, let's say a buyer comes in and is like, oh, it's not working, but in fact it is. The seller can take videos and pictures. They'll have timestamps. Usually they will do this before they leave the property. They could take a video of walking around the property. Everything is fine. Take a video of these things working and so forth. Now, these can be effective really to ensure that the chattels are in working order, as I stated, by acting of what we call a form of security for the purchaser. The holdback provisions allow a portion, as I said, like $5,000 of the purchase price to be held back for a specified period. So you want to make it as tight as possible so that it's not left for interpretation. Okay, so something along the lines that this holdback is, from the moment of closing to the next day in the morning, and so forth, right? So it allows the purchaser to leverage, address any breaches of representation warranties by the vendor, and the mechanics, like say if there's like mechanical problems and so forth, because these tend to come up later on after closing, right? Like someone will say the dryers or the washer's pooling water, right? Like again, like when the deal is firm, the deal is firm. That should have been negotiated in the beginning. Resale deals often feel safer, but they move quickly and leave very little room for error once firm. Okay, now what I want to look at is the pre-construction purchases, which are a completely different animal. Okay, with these, the agreement is typically 30 plus pages long. It's written by a builder's lawyer, okay, and packed with fine print. The deposit structure and closing timelines are much more complex, so I'm going to break it down a little bit. Okay, the deposit structure, buyers usually pay in stages. Example, $5,000 on signing, then 5% in 30 days, 5% in 90 days, and so on. This can add up to about 15 to 20% over time. In Ontario, new build buyers get a 10-day cooling period to rescind the agreement. After that, they are locked in. So during the cool-off period, it is imperative, and I'm really pushing this because I think it's very important. Okay, it is imperative that you get a lawyer to review your contract, to review every clause in your contract, make you aware of what you're agreeing to, and whether you want to consider negotiating some of the terms of the contract. Okay, and what we typically do here is when we're reviewing contracts, we put basically there would be the actual clause, then we lay it out in layman's terms so our clients understand the legal what it's legally being said in that clause. Okay, closing timelines, often years away. First comes interim occupancy, then final closing. Both dates are flexible and can be extended by the buyer legally and within reason. Buyers need to also may be also responsible, so we call it adjustment and hidden fees, for thousands in closing adjustments, developmental charges, utility hookups, HST discrepancies, many of which aren't capped. And then you have the assignment clauses, which everybody wants to know what the assignment clause is saying. These allow buyers to assign their unit before closing, but only if permitted and subject to builder approval and fees. I've seen all kinds of assignment clause. I'll show you an example later on in the webinar. But one of them I've seen is that 90% of the units need to be sold before a builder gives permission. That's something you need to look at if you're an investor. Another area we see a lot coming into our practice is basically the capacity to enter into the contract, right? You know, if you're 16 and 17 years old, you're signing this new deal, you don't have the capacity to enter the contract. You don't have the capacity to enter into the contract, okay? Basically, in Ontario, it is presumed that anyone over the age of 18 has the capacity to enter the contract or manage the own property. There is a test for mental capacity. The mental capacity required for entering into a contract is determined by whether the individual can understand the nature and consequences of the transaction at the time of contracting. The contract is voidable, not void, if the individual lacks such capacity, provided one party knew or ought to have known the incapacity. The test is not about the mental state in general, but specifically about the ability to comprehend the transaction in question. A voidable contract, which I need to inform you all so you understand, is a valid agreement that can be legally voided at the option of one of the parties. This means that while the contract is initially considered valid and enforceable, one party has the right to cancel or rescind it due to certain circumstances such as misrepresentation, fraud, undue influence, or lack of capacity. If the party with the right to void the contract chooses not to do so, the contract remains valid and enforceable. One of the biggest risks we see, buyers assume appreciation. But if the market turns and the appraisals come in low, they can't get financing and can't close. Also, don't forget, Tyrone warranty, it does protect new home buyers against certain defects, but not failed closings or financing issues. Okay? So while resale deals are fast-moving, conditions are sensitive, new build deals are slow-moving and full of legal landmines. In both cases, deposits are exposed, timelines matter, and conditions must be respected, not just contractually, but practically. Many buyers, even agents, underestimate how fragile these conditions can be. In the next section, we'll look at what actually causes deals to fall apart and where the trouble usually begins. So now that we covered how these deals are structured most of the time, let's talk about what causes them to collapse. While every case has its nuisance, there are 5 key failure points we see over and over again in practice, especially here in Ontario. Number one, the financing falls through. This is by far the most common cause of failed closings in both resale and pre-construction. A buyer may get pre-approved for a mortgage, but the final approval depends on several things. The property's appraised value, okay? The buyer's current financial picture, which may change between offer and closing. The lender's risk tolerance in a shifting market. In new builds, buyers may sign years before closing. By the time their unit is ready, interest rates have climbed, the unit doesn't appraise, or the buyer's income situation has changed. If the lender pulls out at the last minute, the buyer simply can't close, even if they're legally obligated to. Okay? In Ontario, this is not usually a valid excuse to walk away. Courts have ruled that financing issues, usually specifically conditioned in the contract, do not release a buyer from liability. Okay? We have unmet conditions is another area. So in resale transactions, conditions offer legal escape hatchets, but only if they're properly used, right? The common problems include missing the condition deadline, waiving conditions under pressure, only later to discover an issue, ambiguous language, the condition itself, leading to disputes. In court, if the buyer waived the condition but now claims that they couldn't close because financing didn't come through, they're on shaky ground, okay? As what I'm gonna keep enforcing in this webinar. So you need to have clear documentation and legal advice at the condition removal stage, which I would say are the critical, are really crucial for you to continue on with the purchase. Another area we see is buyer's remorse or cold feet. Okay, this one's more emotional, but still very common, especially in volatile markets. Some buyers overbid in a bidding war, then regret the price later on. Then you have the some buyers read the builder's agreement post-signing and panic. Then you have some buyers who get cold feet before closing due to market conditions or personal reasons. Here's the truth. Once the deal is firm, changing your mind is not a legal defense. Unless the contract includes a clear-out clause or unfulfilled condition, the buyer can be held responsible for losses, including resale losses if the seller or builder later resells the property at a lower price. Always remember, the seller is selling and the buyer is buying, and if the buyer cannot close due to financial reasons, that's the buyer's issue to deal with. Buyers must be aware that making offers and signing contracts of this nature should not be taken lightly. If you are thinking of purchasing a resale or a new build, you must assess your financial situation. Determine in advance where your money will be coming from and seek advice from a lawyer and advice from a mortgage broker, a financial professional. For example, if you're doing investment and you have a diversified investment portfolio, a real estate agent, all that advice you receive, you should be taking into consideration. Don't think because someone is telling you at this point you can't do something that they're working against you. They're there to work for you, okay? Now, in new builds, problems aren't always on the buyer's side. Okay, builders may fail to complete the unit or home by the extended outside date. They may breach the agreement, for example, by delivering a significantly different unit or house than promised, such as reduced square footage, missing or downgraded finishes, major layout changes, or material deviations from the original specifications. This can really include things like switching hardwood flooring and laminate, removing balconies, altering kitchen layouts, lowering ceiling heights, or even changing the location of windows and structural elements. In new build agreements, these changes are often justified under what's called builder's discretion or minor modification clauses. But if the deviation materially impacts the value or livability of the property, it may amount to a legal breach, especially if not clearly disclosed or consented to in advance. However, take a look at this. Okay, so this is a new build condominium agreement of sale purchase. This is really on top of the clause here, so it's about 1, 2, 3 paragraphs. There's a heading that states changes in condominium. We couldn't put it in there because we wanted to make sure we fit in the 3 paragraphs in there. So this clause, in layman terms, outlines the rights and obligations of the purchaser and vendor regarding changes to a condominium during construction. So it talks about the condominium will meet building code standards at the time the building permit is issued. It goes on to say that the purchaser cannot claim against the vendor for not meeting higher standards of workmanship, materials than those than those required by the building code. It has things about estoppel, which states that the vendor can use this clause to prevent the purchaser from making claims about workmanship or materials in the future. It states that the vendor can change the building specification, site plans, or materials without the purchaser's consent to comply with legal or architectural requirements. It goes on to state that the vendor can substitute materials with those of equal or better quality as determined by the vendor's architect. And then it goes on to finally state that the vendor is not required to notify the purchaser of these changes. The purchaser agrees, once they sign this agreement, to these potential changes and must complete the sale regardless of modifications. Overall, it limits the purchaser's ability to consent to changes made by the vendor during construction. And further, we're looking at the same agreement here. This clause is added, which states representation and marketing materials. It's clause 30 in this agreement. It's about 1, 2, 3, 4, 5 paragraphs. And this clause itself clarifies the limitations on representations and marketing materials related to the condominium purchase. So it goes on to state that there's no warranty on marketing materials, and which the vendor does not guarantee any information in brochures, drawings, plans, advertisements, or statements by sales representatives regarding the unit's area or other matters. It goes on to discuss approximate measurements. So it indicates that dimensions, ceiling heights, and other data and marketing materials are approximate. The purchaser is not buying based on price per square foot. It goes on to say that no refunds for variations. The purchaser cannot claim a refund or price reduction based on the final unit size, configuration, or ceiling height. No warranty on chattels or furnishings, right? There's no guarantee regarding the size or location of chattel or furnishings within the unit. And it talks about conceptual marketing materials. The marketing materials and site drawings are conceptual and subject to change. They do not form part of the agreement or provide any warranty. And then the views and distances of views shown in plans or renderings are approximate and may change during the construction. Okay, so overall, these clauses limit the purchaser's reliance on marketing materials and representations, emphasizing that they are not part of the contractual agreement. So again, this is in a new build contract, right? So you must go through your contract in detail with the lawyer, and the lawyer must explain these things to you. Now, another area that we see is the builder goes bankrupt during construction. Okay, so for example, on Bloor Street and Yonge is an example where we have the tallest building coming up in Toronto. In 2023, a receivership order was granted to the build due to cost overruns, delays, and substantial amount of debt and mismanagement of the project. Okay, the project's original general contractor was estimated to be $1 billion plus in debts and was removed. Skygrid Construction took over, and now Tridel is doing the project, right? They've just been hired to complete the construction project. The project is set to complete sometime in 2028. Some of the drawings have changed, but it really this project is an example of how things really turned out to be a disaster. Okay, so you may need to follow the news on that one, and see how the courts, because the news will give what the courts are saying, okay, in terms of what's happening and so forth. In these cases, buyers may have a claim to rescind the agreement and recover deposits, but it's not automatic. They often need legal help to enforce their rights. Okay, so the Ontario New Homes Warranty Plan, enforced by Tehran, provides some buyer protection, but mostly for construction defects, not contractual disputes or delays. And not all builders are registered with Tehran, okay, which adds another layer of risk. Okay, so you have the standalone builders there, okay? In fact, under Ontario law, any builder or vendor of a new home is required to be registered with Tehran and enrolled in the warranty program before entering into a purchase agreement or beginning construction. If a builder operates without Tehran registration, they are not only violating the law, but they are also leaving the buyer completely exposed with no access to statutory warranty protections for deposits, refunds, delayed closings, or structural issues. Before signing, buyers should always verify the builder's registration status directly on Tehran's website. If the builder isn't listed, there's a serious red flag and a reason to walk away or speak to a lawyer immediately. These new build contracts will also have documents related to Tehran in them. Another area which is extremely relevant in today's pre-construction market and a lot of investors is many buyers, they are entering deals planning to sign their unit or their new build home before final closing. This means they plan to sell the contract, not the property itself. But assignment is not always guaranteed, as I explained. It must be permitted in agreement, and the terms can be surprisingly restrictive. Assignment clauses in builder agreements can often include, and I'll show you guys one in a minute, a requirement for the builder's written consent, which may be withheld for any reason, a non-refundable assignment fee, often ranging from $5,000 to $10,000 or more, a clause allowing the builder to approve and reject a new buyer, restrictions on marketing or listing the assignment publicly, example, no MLS or online advertising, a deadline after which assignment is no longer allowed, sometimes only within a specified window before closing. There are, I take it some of our viewers are real estate agents that deal specifically with assignment clauses and assigning the contracts. So they may appear to allow assignment, but included language that make it impossible in practice, such as requiring the builder to act at their sole discretion. So at their sole discretion, or to charge escalating administrative fees. If assignment rights are important to a buyer, especially investors, those clauses should be carefully negotiated or reviewed by a lawyer before signing. Okay? So this is a clause, it's titled in this agreement, it's the same agreement we're looking at, restrictions on assignment and leasing. Okay? So you could see how very, very detailed, how very much detailed it is in the new build agreement. Okay? It is imperative, right, that you get clear legal advice on this, because if all of you are intending, and I've seen it, a lot of it comes through our door, to assign in the future, you need to prepare in advance. If it doesn't fall through or you can't, what's the next option? Okay. So again, you see here the money here that they're listing in liquidated damages if you fail to follow what they're asking you to do in terms of how you're supposed to sign. So the builder often charges high fees and must approve the assignee. Market conditions can shift and there can be no takers, as I've explained, at the buyer's price point. When assignment fails, the original buyer remains on the hook to close, and if they can't, they risk losing the entire deposit, plus being sued for damages if the builder resells at a loss, and we're seeing that happen now. It's all over the news. Okay, so basically these are the another area you need to look at. Okay, so whether it's financial, right, emotional, or structural, failed closings usually come down to a gap between what was expected and what could actually be delivered. In the next section, we'll talk about what happens next. What are the legal consequences of walking away from a deal? Who keeps the deposit? And can you actually be sued for backing out? So the deal didn't close, what now? Whether it's a resale or a new build, a failed closing doesn't simply go away. There are very real legal, financial, and reputational consequences. Some immediate, others long-term. So let's break it down. In Ontario, deposits are generally held in trust, either by the real estate brokerage in resales or the builder's lawyers in new builds, or if the lawyers are negotiating and drafting these APSs, one lawyer will agree to hold that money in trust. But once the deal collapses, the deposit just doesn't disappear. Here's how it works, okay? If both parties agree that the buyer defaulted, the seller can often retain the deposit as liquidated damages, a mutual release can be signed, and there could be a negotiation where you're paying extra costs as the buyer, right? Do you agree to at a certain amount plus a deposit and a mutual release? That would be a simple way of going about it. But if there's a dispute, the deposit holder can't release the funds without joint consent or a court order, okay? That means a lawsuit is often required just to determine who gets the deposit, even before discussing for the damages. The brokerages would be also often named in lawsuits. There can be agreements made with the brokerages that the money will, and between all the parties in the litigation, that the money can be released from being held by them to being held by a lawyer in their trust account. In resale deals, we frequently see deposits ranging from $10,000 to $100,000, and in new builds, stage deposits can total hundreds of thousands of dollars. Okay, so in a new build, this is how a purchaser's default looks like. Okay, and you could see it's broken down. It's a huge. The title is there, purchaser's default. It's broken down into two clauses. Unfortunately, we couldn't fit the two clauses in there, but it's huge, and it's imperative that you understand these clauses, okay, and you know what you're signing up to. I'm not trying to scare anybody from taking this step and investing and purchasing properties and growing a portfolio or moving or all that stuff. It's just you need to understand the risks associated with that, because you can lose a lot of money, okay? And you could be sued and you could be held in court, judgments can be given, etc., etc. So I've dumbed these clauses down. So when I mean by dumb them, I've made them down. I've interpreted them in layman terms, so I'll explain to you these clauses, okay? If the buyer defaults, the seller can cancel the agreement or suspend the buyer's rights. The buyer loses any money already paid, including deposits and payments for extras. The seller doesn't need to prove any loss to keep the money. The seller can also sue for additional damages. Leaving the property is also outlined here. If the agreement is canceled, the buyer must leave the property immediately, clean and undamaged. The buyer must sign documents confirming they have no claim to the property. If the buyer doesn't sign, the seller can act on their behalf using a power of attorney, and we see that here when they say Power of Attorney Act or the Substitute Decision Act. Late payments. Late payments incur a 24% annual interest rate, compounded daily. If the buyer delays moving in or transferring title, they pay $200 per day plus legal fees. Legal notices. The buyer pays $250 plus taxes for each notice sent by the seller's lawyer about any default. And deposit handling. If there's a default, any deposits held in trust are released to the seller and the buyer cannot claim them back. Okay? Even if the seller later resells at a profit, the court may still award them the full deposit because the contract, the court or the arbitrator or whoever you decide to use, depending on what the contract is saying, they could simply say it's a black and white contract. You had the opportunity to get legal advice before signing the contract. You haven't, the full deposit is still going to be awarded to the builder, depending on how the original contract was breached. It's all really fact specific, but the first starting point is what's in the contract. Another area you have is contractual liability. You may still be sued. So a failed closing often leads to a claim for damages. And here's a common scenario that I've outlined. This is a common scenario that isn't fact specific. It's just a common scenario. Okay, a buyer agrees to purchase. So what I mean by fact specific, there might be other facts as to reasons why this deal didn't go through. Okay, for example, you might have been negotiating, mitigating, all that stuff, right? But this is just typically what we see, okay? A buyer agrees to purchase a resale home for $1.2 million, but fails to close. The seller relists and sells the months later for $1.05 million due to market decline. The seller sues the original buyer for $150,000 loss, plus legal fees and carrying costs, i.e. if they had to keep the mortgage, they had to get, let's say there's refinancing to keep it, let's say they had to stay, utilities, storage, whatever the case may be, okay? On top of obtaining the deposit, right? So they get all this on top of obtaining the deposit. That's why you need a really good lawyer. If you're in this position like our firm, we negotiate the ways for you to pay less if you're in that position, okay? Sometimes you have to go through the process, which is fine because it's better for, sometimes for the other side to know your financial situation when agreeing to work out a settlement. So in Ontario courts, as what I've been making clear, in Ontario courts have upheld the seller's right to recover damages, and buyers can't simply walk away citing financial difficulty or market shift as an excuse. In new builds, the builder may resell the unit and still come after the original buyer for the difference, especially if prices have dropped since the original sale. Even personal reasons or mental stress don't usually qualify as a legal excuse. Another area for consequences for failing to close is really your reputational and credit damage. Beyond legal liability, failed closings can affect real estate agents and mortgage brokers, obviously, especially if you're working on commission, which you are. And your reputation might take a hit with clients or lenders because of if your clients are trying to claim negligence, okay? Buyers who actually may face credit consequences if sued, the emotional, financial burden of having to deal with a lawsuit, having to retain a lawyer, pay legal fees. There's no certainty in litigation. And if a judgment is obtained, obviously that's not going to be good. If you get a word on your name, if wages are garnished, you decide to buy, that has to be cleared. There's a whole bunch of stuff that, that can come with it. So I tend to say where can we get the money? Let's try to figure out a way. Is there people you can get money from? Is there property that you can refinance? How can you do this, okay? Sellers who may also lose valuable time, holding costs and market momentum, okay? So a seller might be I'm taking advantage of this market right now. I'm selling at the best price I can get, and then eventually they don't, and it's really discouraging for a seller. So like I said, for professionals involved in the transaction, repeated deal failures can also lead to regulatory complaints or disciplinary action. The short version, failed closing can become a multi-layered legal problem. Deposits can be tied up for months or years. Lawsuits can emerge from both sides. And once the matter reaches court, you're being sued, for example. If you're being sued, you're going to bring a third-party claim against, the professionals. It's a lot of money. It's a lot of time. Obviously, it can happen. It's really based on instructions you give your lawyer and facts, okay? Once the matter reaches court, legal costs can be quickly surpass the original dispute because you're going to be paying your lawyer. Depending on the outcome, you may have to pay the other side's lawyers. In the next section, I'll talk about legal rights, duties, and remedies, and what Ontario courts actually look at when evaluating these kinds of disputes. At this point, we know how deals are built. fall apart, and what happens when they do. Now let's get into the legal heart of the matter. Okay, who's responsible? What duties they owe, and what remedies the law provides when a closing fails. We'll look at this from 5 angles: the legal duties of real estate and mortgage professionals, contractual duties of buyers and sellers, what Ontario courts look at in failed closing litigation, what remedies are available, and some common claim types and defenses that arise in court. Right? Now, real estate agents and mortgage brokers are more than the facilitators. Okay? They owe both statutory and common law duties. Under Ontario's Trust in Real Estate Act, Services Act, and the Mortgage Brokers, Lenders Administrative Act, a professional must act honestly and with integrity, disclose material facts, example known issues with the property or buyer qualifications, explain risks clearly, especially regarding conditions, financing timelines, and assignment clauses. Negligent misrepresentation or failure to disclose can expose professionals to personal liability and regulatory discipline. Example: if an agent pressures a buyer to waive conditions without ensuring mortgage approval and the buyer later defaults, the agent may be drawn into litigation for failing to act in the buyer's best interest. And they can be drawn into litigation by way of a third-party claim. Now, duties and liabilities of buyers and sellers. Both buyers and sellers have strict contractual obligations when the deal becomes firm. Buyers must deliver the deposit as agreed, securing finance if not a condition, close on time, and provide the required closing documents and funds. Sellers must deliver clear title, and in the resale agreement, I'll tell you when you have the ability to do a title search for a buyer. Discharge all encumbrances, vacate unless otherwise agreed, cooperate in good faith throughout the process. Any deviation, even 1 day late, unless it's negotiated, can be treated as a breach of contract. In Ontario, courts take a strict view of real estate contract enforcement. Parties cannot rely on informal excuses or good faith alone to avoid liability. What courts consider in failed closings? When these disputes end up in litigation, Ontario judges look at several factors. Who breached first? The party in breach generally cannot sue unless they've corrected their own default first. Was there a genuine attempt to close? Courts assess whether the party tried to secure financing, gave notice of issues, or simply disappeared. Were timelines and conditions followed exactly? Courts don't take lightly to miss dates, even by 1 day. Time is most of the essence in real estate deals. Okay? And there is a clause in resale agreements about time. Did one party act in bad faith? Example: did a seller deliberately make it difficult to close, or a buyer ghosting the seller weeks before closing? Okay? Evidence like email chains, document trails, and communications through agents, through lawyers, are key in determining credibility and intention. Now, legal remedies available. The legal toolbox is broad. Here are the most common remedies. One, as I've explained already or alluded to, forfeit of the deposit, right? A seller may retain the deposit as liquidated damages, plus a negotiation can happen that you pay an extra $10,000. A mutual release is signed. But if no mutual release is signed, they may sue for more. Okay. A buyer can bring a specific performance. So a court may order the buyer and seller to complete the deal, especially in unique property cases where money is an adequate substitute. Okay. If a party suffers loss due to a breach, including price differences, legal fees, and carrying costs, they can claim damages. In rare cases, the contract may be rescinded or canceled. For example, if there was fraud, fundamental misrepresentation, or mutual mistake. And mitigation obligation. So basically, the non-breaching party, i.e. the seller, usually, must make reasonable efforts to mitigate losses, such as reselling quickly and fairly. Failing to mitigate can reduce the damages award. Typically, the seller will, if they put it up for sale, they would want to keep all the offers that came through, and basically to show that it wasn't the same amount of what was sold. So there's a minute. It's not only that you mitigated the damages, but you've kept proof that you weren't reaching the same amount that the original, let's say, resale offer came through. That can't continue. So here are some examples of real claims and common defenses. Buyer backs out of a 1.4 million resale. Seller resells for 1.2 million and sues for 200K difference. Court awards full amount plus costs. The buyer's defense: I couldn't get financing. The judge: not a valid excuse. Okay. The seller breached first is a common defense that can be raised. Example: fail to discharge a lien or vacate the property. Second, and not only vacate the property as a seller, but if they have tenants, or the buyer's not assuming those tenants and the tenants haven't been removed from the property. There was no genuine attempt to mitigate. Force majeure or frustration of contract. This is rarely accepted, and the resale agreements will have those clauses in them unless it's truly unforeseeable. And again, misrepresentation, example, non-disclosure of known defects, unless you're buying the property as is, where is, right? There's a crack in the foundation. The seller is aware there's a crack in the foundation. The seller is selling the property as is, where is, made it clear they're selling it this way. You can't come back. It's very difficult as a buyer to come back and try to sue the seller on that. These arguments are really fact-specific and require clear documentary evidence. The law doesn't give in much sympathy to parties who simply change their minds or fail to prepare. Courts in Ontario accept real estate agreements to be honored to the letter. In this next session, we'll sift from law to strategy and talk about how to protect yourself from ever getting to this point in the first place. So far, we've seen how deals fall apart and how the law responds. But let's take a step back and ask a more useful question. How can you protect yourself or your clients before a deal goes off the rails? Whether you're a buyer, seller, investor, broker, or lawyer, these strategies can help you stay ahead of risk. For buyers, the number one rule is this: don't assume pre-approval equals guaranteed funds. Get firm financing commitments before waiving conditions. If buying pre-construction, plan for rate increases or appraisal gaps. Work with a mortgage broker, financial planner who understands builder timelines and assignment risks. Many failed closings happen because buyers waive financing clauses too soon or ignore the fine print in their mortgage approval. If your financial picture changes, your lender's commitment can vanish overnight. Understand every clause before you sign. Whether it's a resale or a 40-page builder agreement, make sure the client or you actually understands what you're signing. Okay? In resale, review conditions, timelines, and obligations. In new builds, get legal review before the cooling period ends. Watch for hidden builder charges, assignment restrictions, and cap limits. Don't rely on assumptions or verbal explanations. Many disputes come down to what is written and not what is said. Document everything. In every resale real estate deal, assume you may end up in court one day. I know I'm laughing at that, but it's really, I think with everything you do in your life, you should assume that you'd end up in court one day. So keep records of communications, confirm verbal agreements in writing, store all condition waivers, status certificates, financing letters, and notice of extension. Okay. In litigation, who has the better paper trail usually wins, especially if you take the stand and it becomes down to credibility, he said, she said, and you have something backing up what you're saying. Courts will look at that, right? So they'll place high and weight on documentation and email exchanges, and at the time of the deal, not really after, okay? And in the middle of trying to make the deal. let's say trying to negotiate all that stuff, okay? Use real conditions, not cosmetic ones. Avoid using vague or half-hearted conditions just to buy time. If you include a financing or inspection clause, use it seriously. Make sure your condition is worded properly. Make sure your holdback is worded properly. Attach a real deadline. Include the right to terminate. Use wording that gives legal protection, not just negotiation leverage. Sloppy or cosmetic conditions can backfire in court. Worse, they may not protect you at all. Okay. Get legal advice before trouble starts. Too many parties only call a lawyer after the deal collapses or it's close to collapsing in a new build, okay? You have a week left, right? And we get the call, right? Instead, consult legal counsel before the drafting, review, or condition waiver stage. If you sense risk, delayed financing, developer silence, buyer hesitation, get proactive legal advice. A 30-minute call can prevent a 2-year, it could be 2 years, it could be more, lawsuit later on, okay? Real estate deals move fast, especially in Ontario's high-pressure market, but rushing through them without legal and financial clarity is what leads to litigation. In the next section, we'll look what actually happens in real cases and how different choices could have changed the outcome. So we're looking at a couple case study. Here are I'm going to give you 3 simplified stories from real Ontario cases. Okay. Number 1, a couple buys a pre-construction condo in the GTA for $850,000 in 2021. They put $170,000 in deposit. Fast forward to 2024, interest rates have doubled and the final appraisal comes in at $780,000. Their lender will only finance 80% of the appraised value. The couple can't make up difference and walks away. Result, the builder resells for $765,000. The original buyers lose their $170,000 deposits and are sued for the $85,000 loss. They also pay the builder's legal fees. This outcome was possible because the builder's agreement included a strong default clause, which clearly stated that if the buyer failed to close, the builder could retain all deposit payments and sue for additional damages, including resale losses, carrying costs, and legal fees. These default clauses are standard in most builder agreements and heavily favor the vendor. Buyers often sign them without realizing just how exposed they are if they can't close. What went wrong? No legal review of the builder agreement before signing, no backup financing strategy, no assignment clause negotiated. What could have helped? Capping closing adjustments, early legal advice before firming up, and assignment flexibility. Case number 2, the last-minute backout on a resale. A buyer purchased a detached home in Oakville for $1.4 million with a 5% deposit and no conditions. 3 weeks before closing, they panic. Media headlines say the market is crashing. They try to renegotiate, and when the seller simply refuses to close. The result: the seller relists 2 months later for $1.2 million. The court orders the original buyer to forfeit their $70,000 deposit and pay an additional $130,000 in damages, plus interest and costs. What went wrong? No financing condition included. Emotional decision without legal consultation. Failure to formally notify or negotiate before default. What could have helped? Legal advice as soon as second thoughts arose. Proof of good faith effort to close, and understanding that real estate contracts in Ontario are strictly enforced. Case number 3. A mortgage broker encourages a buyer to waive their financing condition before a commitment was confirmed. The buyer defaults when financing fails and is sued. They turn around and sue the broker for negligence. The result: the court finds that the broker acted carelessly in pressuring the buyer to firm up the deal without a valid approval. Damages were split and the broker's license came under regulatory review. What went wrong? It's a breach of duty of care, no documentation of client's informed consent, overstepping professional boundaries, because it's the real estate agent that should tell them to waive the condition or not. What could have helped? Clear written communication about risks, professional boundaries and full disclosure, documentations of client's decision and understanding. Each of these outcomes could have been avoided with better communication, either legal intervention and clearer contract terms. In our final section, we'll open the floor to your questions and tackle what's relevant to you and your clients. Before we jump into the questions, I want to leave you with this. So at ME Law, we don't just step in after the damage is done. We work with buyers, sellers, brokers, and developers at every stage, from reviewing agreements before they are signed to representing clients in high-stake litigation when closings do go wrong. If you're currently involved in a transaction, if a deal feels unstable, or if you're advising a client who's nervous about what's next, now it's time to talk to a lawyer. We offer strategic consultations, contract reviews, and litigation support focused on protecting your investment, your time, and your peace of mind. You can take a screenshot here so you can reach out to us directly. We have a QR code for new clients on related to discount that they can get for a consultation. Let's open up to your questions. Thank you, everyone. So, Michael, thank you for your question. Obviously, it really comes down to what was in the agreement, right? Like, it is a recent problem. You're saying here that puts the buyers on interim occupancy at astronomical interest rates. Like, did you speak to a lawyer? I think it's best to speak to a lawyer, because what usually happens, and I'm gonna be frank about this, is that sometimes when lawyers get involved, it's easier to talk and discuss things, okay, versus not having a lawyer involved. It's very, very difficult to do things on your own, okay, because lawyers will review the contract. They will review any communications or documents you receive from the builder throughout time. They will be able to discuss, because there are instances where when a lawyer comes in, especially a litigation lawyer, they halt noting you, and like they basically halt with the default stuff. So the position of the lawyer would be that we've just been retained. Can you not proceed with the default and so forth? We're going to review the contract, review the stuff, and speak to our clients. So it's very much important that you get that person working for you. So I think your question is more fact specific. So we need to look at that. It's not really the real estate agent having to go in and speak to your lawyer. There are, many years ago when I started this practice, I actually had a real estate agent that I worked closely with. So when they had issues come up during the contract signing, I would deal with that, right? So if they had issues, the client wants me to review the contract before they finally signed it, I would always do that, right? So I had that relationship with the agent. So we have a lot of relationship with the agents like that. So if the agent wants us to review the contract for their clients, or they're trying to work out a deal, because you got to understand, an agent is a professional. That agent already has a duty to do certain work for you. They've already been through their training. Their job, their bread and butter is putting these contracts together. But if there's issues that come up, your agent can work with a lawyer and can be clear on that you want the lawyer to review this. I can get, the lawyer I'm working with. So like I said, we work with a number of agents pre-finalizing agreements, right? So it really depends on the relationship you have with your agent, and whether your agent, send your agent here. We'd be more than happy and willing to work with them side by side on looking at these agreements. Okay. Give me 1 sec here, please. I'm getting a lot of questions, you guys. I'm not going to be able to answer all of them. So, Mr. Singh, it's very fact specific. I suggest that you take advantage of the QR code, and we can do a paid consultation, because the buyer is a corporation, right? A corporation's a legal entity, and they can go after the corporation. So we can chat about that. Okay. Now let's see what else we have here. So you got to understand, in terms of personal liability of the director, they have to pierce the corporate veil, right? So, but they are going to name the director if they come to make a claim against you, right? Okay, so I'm looking because the questions are coming on a different computer, so I'm looking at them. So it looks like I'm not looking at the camera. Okay, so again, like these are very fact specific, and it's very, very important that something like this, that we can talk about it, because some people will have corporations and have holding companies. The holding companies will hold real estate. It's a very different structure, but it doesn't immune the corporation from being brought into litigation. I think there's so Mr. Singh, like again, like if a judgment is handed down and a judgment is brought against you or brought against somebody else, they can put words on your name so you can never ever buy anything, right? Till you clear that word, the word, sorry, which is a judgment. And they could also like garnish wages. So that's a different set of stuff that happens after. Okay, it's very, very much important that you have to understand there's a process in this, right? You don't want to get to the point where they're gonna garnish your wages. They can ask you questions. If they get a judgment, they can do what's called an examination in aid of executing that judgment. They will ask for statutory declarations of your assets. They will get your bank statements. They will find out whether you're, funneling money, whether you put money into property in someone else's name. So it's beyond this discussion today, but it is something that you need to turn your mind to. Okay. So that's a good question, Anwar. It's really because is the estate. So now this is the thing, because the person passed away. So this is what's really cool about our firm, is that we do estate litigation, and a lot of our estate litigation area overlaps with we do corporate commercial, we do and real estate litigation. They're standalone, but a lot of them overlap, right? So some of this, again, like we got to look at the agreement if there's something about like someone stepping in, like what we saw, like the builder's relying on a power of attorney and the substitute decisions act to basically say that we're signing on behalf, right? So typically what we have to do is that we have to speak to the builder, say the person passed away, the contract is no longer void. Is someone else in the estate coming on and taking it on? Is it going to be an estate property, right? So does it belong to the estate? Are the beneficiaries taking it? Are the trustees going to handle it? So the estate trustee has to get involved in this process. So again, that's very fact specific. It's a unique situation, but we deal with all of that here at ME Law. And and I just want to highlight, if there's no contract, so you cannot, if you're not contracted to use the real estate agent, then they shouldn't be making any deals for you. So filing for bankruptcy isn't something you rush to, okay? So you got to make sure that you're not filing for bankruptcy in order to defraud your creditors, right? It is a way that you can use that to basically assist in coming to resolution, but you can't just, I would not suggest you do that, and I'm not going to tell you to do that. I mean, this is not one-on-one legal advice that I'm giving on here, but you don't want to be found to have done that to defraud your creditors, right? So it's another area we do here at the firm. And again, as you can see, it's very complex. There are different nuances to it. There are things we need to look at. There's fact specific, because it could be, like I said, it could be as basic as negligence or of the professionals, like let's say the real estate agent or the mortgage broker. It could be that you didn't get advice, whatever is happening, it often leads to what discussions we have on the best move forward. Okay, so we need to have things really important on moving things forward. So we need to have looked at all the facts and in order to move forward. Well, it really depends, because if the contract's been amended, you're no longer part of that contract, right? So if your name has been removed, that means all liability. So you might have had to sign something, the laws, like if you're no longer part of a contract and you're removed, you shouldn't be being like, okay, it's more complex than that. Okay, so for example, I'm going to use an example here. You're selling a business, right? A moment of sale of a business, you're no longer liable for whatever happens in the business. Before that, when you were part of the business, then you might be liable for anything that's coming forward. Okay, so what we need to do is we need to look at your contract where it states that, and we need to confirm from the builder that you're not liable because the deal fell through. So there has to be that confirmation. There should have been that confirmation in the beginning, right? You know, you don't want to do something with someone later on saying they can still go after you, right? So you need to make sure. See, that's why it's so important that you really know your rights, because if you're coming out of the contract, your position should have been that if the other party fails to close, I'm not going to be liable for that. Let's make it clear. Let's have an agreement signed and so forth. Anyway, I'd love to chat with you guys some more. I absolutely enjoyed covering this topic. I really appreciate it. We're going to host another webinar. I'm figuring out a time for that. Thank you for joining us today. Have a good day and enjoy the rest of your week.